So we are going to go ahead and get started this morning. My name is Elizabeth Aloni, and I'm with Schneps Media. Schneps Media is the largest local media company, and we publish over 70 newspapers, magazines, webinars, websites, podcasts, and events throughout Queens, Brooklyn, the Bronx, Manhattan, Westchester, and Long Island, and Philadelphia. And we today are thrilled to bring you the Asset Protection and Elder Law Workshop with the incredible Donna Stefans. We are very lucky to have her here with us today. And she is a true expert. She has over 2 decades of experience, and I'm really thrilled to introduce Donna Stefans. Donna is the Stefans Law Group lead estate and elder law attorney. She's also the president of Summit Tax Advisors, and she's an investment advisor representative with Cetera Network Advisor LLC. Amazing. Donna and her team offer a unique trifecta to their clients to cover all their financial needs from starting a family to the sunset years of one's life. They are truly a one-stop financial services organization. Welcome, Donna. You're just on mute, Donna.
Good morning, everyone. And thank you, Elizabeth. Yes, so I'm excited to be here with you today because what I would love to do is work with you in a way that you could look at what you have going on in the planning end of your world and maybe some of the issues you will have to face, if not already facing, and hopefully put some check marks on some things like, I did that. Oh, let me think about that. There's no right or wrong, and there's no one size fits all to asset protection, elder law, and estate planning. And so if there's something you haven't done, don't beat yourself up about it. But today is a head start for you to get on the path of planning. So you're already on your way. But let's get started with some information about what are we really talking about. And I'm going to get on my PowerPoint here with you.
She's going to share her fantastic presentation.
Yeah.
Looks great.
Okay. This gets a little, okay. So this is reality. Okay, we all don't want to really think about these things, but at least 70% of people over 65 will need long-term care services and support sometime in their lives. 70%, right?
Wow.
And 59% of all assisted living residents will probably need some type of skilled nursing care, which means you could plan on being in an assisted living. It's a great idea, but many will need further care than that. That means lots of costs, asset protection necessary. And the reality is the majority of those people are women. And the numbers. Now in New York, we have great benefits and services through our Medicaid programs. However, we can't always get there quickly and in the time we need care. So the average cost of a nursing home stay today is $419 a day, which equates to over $12,000 a month.
Wow.
Ouch.
Wow.
And that means over $150,000 a year.
Mm.
And that's when you look at your nest egg and go, how long can my lifetime retirement savings withstand that? For most of us, probably not very long. Even if you're a millionaire, that's going to erode very quickly. So you have to do something to insure yourself. And so whether we start talking about asset protection and what to do in the strategy of that, or simply look at long-term care insurance, I know most people say, oh, can't look at that, it's too expensive. You can think about that concept when you think about cost $12,000 a month in a nursing home, slightly less for an assisted living. The reality is home care is $7,000 to $10,000 a month, no matter how you slice it, if somebody really needs care. So there's a weighing thing going on here, and depending on your age. All I'm saying right now is don't close yourself off to something like that to protect yourself. So for less last point on that, excuse me. We think about asset protection and care, or maybe we don't want to think about it, but we definitely all know that someday all of us, we're not going to get away with it. We're all going to die, right? I mean, that's gloomy and doomy, but the fact that I want you to know is that 80% of all men die married or with a partner, but 80% of all women die single.
Wow.
What does that mean? That's a huge fact. What does it mean? It means, ladies, you need to protect yourself, because odds are, if you do the math, you are going to need the care, and your partner's not going to be there to help do that. And, you know, for the men, make sure that not only are you taken care of, that that person next to you is going to be okay if you're gone. So on all those wonderful notes and flowery stories, let's talk about what we're going to talk about. We're going to talk about what I call the fabulous four, your most vital estate planning documents, right, for lifetime care and after you pass away. The use of trusts in elder law and estate planning, a very powerful tool for asset protection today for care. And gifting to children, how does that come into play? Do it, don't do it, good idea, bad idea? Well, we'll see. And finally, an update on the Secure Act for IRAs, because that's absolutely a legacy asset that now has some very drastically not so great rules. And it affects long-term care, but also where we are on Medicaid applications, massive change there too. Hot topic.
I love that you call it the fabulous four, because although it's not the most cheery subject, it is so important and really gives you such peace of mind that it really is fabulous.
Thank you. Yes. I think that the hardest thing for people to do is actually sit down and make the appointment. Because once people get to the appointment, we go through it and we just get it done, right? Mm-hmm. And the thing that's been keeping you up at night probably the most is, what happens if something happens to me and I'm not here?
So
and
true.
I can't help my family and I can't help myself.
Yeah.
You know, it all looms for us. But if you get this stuff in order, then you have the power to be taken care of properly and take care of your loved ones. So,
that's for sure.
But either which way you look at it, it's really excellent if you have what I call the dream team, right? This is a team effort. Besides your family and your village that you have, your financial advisor, your elder law estate attorney, and your accountant are the three people that should be working together for giving you the proper advice and care of what do you have financially, what's the tax implication, the legal plan, how does it affect the financial and tax plan? They all go together. I myself am a financial advisor, as Elizabeth has said. I've been doing that for 28 years. So we, manage portfolios, but we do true financial planning. However, I'm also the elder law attorney, and the legal plan is where you actually have to start. And we take a legal plan, picture it like the skeletal system of the body. You've got to create that solid base that then you put all the rest of the muscles and everything else on it. So the legal plan is the skeletal system, and the financial plan is how you layer it on so all the parts work together. But wait, you better have the tax team, what I call kind of the skin, that's going to protect it all so that we don't send it all to the IRS. We definitely don't want to do that. So you got to have all your parts working together. I myself actually do all three. And we have our teams within my practice that I am very proud of, that we really do work together looking at all the parts of somebody's financial life. Even if we're not doing all the parts, at least we can issue spot it. So there's two parts of this, okay? There is lifetime planning and care needs and emergencies. And then what I call the afterlife, the who gets what and how they get it if I'm suddenly completely gone. But they work together because we don't know when any of those events might occur, all right? But they really come together for the asset protection plan. So without further ado, here's the fabulous four, right? Now, these documents, the power of attorney, the healthcare proxy, and the living will, not the last will and testament, the living will, these are all the life care documents. These are the ones that if you suddenly got hit by a bus and now you're unconscious, who knows? I mean, I say these strange things because nobody's expecting that. But if you became incapacitated and you couldn't speak for yourself and you couldn't handle your financial affairs and you couldn't make a medical decision, who do you appoint to make these decisions and help you, right? Legally, nobody can just step in and do it. So we have ways that we have to do it. Now, you could imagine during COVID last year, somebody leaves your house, they are sick, they go to the hospital, you can't even talk to anybody because you have no authority. Nobody's talking to you, they're not talking to anybody, and the doctors are just making all the decisions. That is frightening, not only for the person going in, but for the family left behind that can't even know what's going on because they don't have a healthcare proxy with authorization to speak. And not only that, the end of life decision making, which we all know was so tragic in this last year. I was doing many hospital signings, nursing home signings, rehab signings, assisted living signings. The social workers and the nurses, they were like my triage team in the room with these very, very sick people that knew what they were doing, but couldn't sign. They signed, but they couldn't get out. Nobody could help them. That's not the time you want to be doing these documents. You want to hire somebody in your village, your cast of characters, your family, your friends. Who is going to be the person that you could trust to handle your financial affairs if you're in the hospital, if you don't have the memory to do so anymore, if you're sick, right? Or frankly, even if you decided to go on a nice vacation, you're not going to be around a while. Who do you trust with your money? Right? Very important. And medical decisions. Who do you know that if you got sick can actually make an informed medical decision and not fall apart because you're not well? So these
Donna,
are very
I have a question about with the healthcare proxy. Is that only come into play when you, let's say, are unconscious? Or if you have a healthcare proxy, can you name individuals that, let's say, are allowed to speak to doctors even if you're alert? Because, like, for example, with COVID, you'd be in the hospital, maybe you're not unconscious, but you want your family to be involved. So would that be something that you would address within the healthcare proxy?
Absolutely. The healthcare proxy, which will be our first document to talk about, is the document you appoint somebody to make medical decisions for you or know under HIPAA authority that you're allowed to discuss medical situations. So let's get to that. It is for medical decisions, medical record access, and that also means what you're saying, talking to doctors, and life support representation. So we start by the fact that we always have a little card that we give all of our clients when we do a healthcare proxy for the wallet, right? Because it's an in case of emergency card. If somebody finds you out on the street, who are they going to know to call, right? So it's there. Also, think about it. You have an emergency situation. You run to help your person. The EMT is called. We're all running out the door. What do people usually take? Elizabeth, what would you take if you had to help somebody? First thing you think of.
My purse.
The purse, the wallet. Last thing you're probably saying is, hey, hold on a minute. Let me go to the files and go start looking for medical records.
Such a good point.
No. So we have the first line of defense, the card, right? Because that's going to be in the wallet. Or supposed to be anyway. But the healthcare proxy can be anything from the person's unconscious, or we have many clients. I am on the board of the Alzheimer's Association, so many people will ask me questions about the healthcare proxy issue. And so if you have a person that they're together, but they're not always mentally with it, and they're declining, it's really important for the healthcare representative to be able to talk to the doctors. And a case in point, had a client, his mother was starting to fail. Now he didn't know exactly. And so, but he was it's starting to not add up. And so she'd go to the doctor, how was your appointment? And she'd say, I'm fine. But then things were not fine. And then with the healthcare proxy, he started calling the doctor saying, hey, what's going on? And it turned out she actually had a dementia diagnosis and didn't tell anybody.
Wow.
Now that's dangerous.
Yeah.
Not only should she probably not be driving anymore, but like she's leaving, going home. And does she even remember that she got a diagnosis? So it can be things of that nature in advance. But again, I think about the emergency situation in a hospital. You're so totally out of control there. You know, you need somebody helping and thinking like clearly when you have things going on. So the healthcare proxy is a must-do vital document for anybody over 18. And in fact, in the summertime, we offer to our clients a free healthcare proxy for their children going away to college.
Wow, huge important point, because once they're 18, they're 18.
They're 18. They are considered adults, whether they act like it or know it or not. And you're done. Your job's done. You can't help them anymore. You can't say. So here we are. You're just off to college. It didn't seem like any different day than yesterday, except for that. And something happens. No hospital is going to talk to you. No doctor. The school nurse is not going to tell you what's going on. So you really want, everybody to have these things. So we do free ones for the college kids because, we all need somebody. And that's a fact. So there's the healthcare proxy. Again, appointing somebody to make medical decisions if you cannot do so. And then there is the end of life decision-making document, which is being the life support representative, called the living will. This is not a last will and testament. These words get like really confusing because there's a living will, a last will and testament, and a revocable living trust. So living will, meaning my will. What is my will? What is my wish about living at this time? If you turn the words around, it makes a little more sense. But it basically says, hey, if the only reason I'm alive is by machines, do I want to live that way or not live that way indefinitely? Right? But usually if you're in this position that the determination needs to be made, then we're at a time that you can't say. So the healthcare person says, hi, here's a healthcare document. See, I'm the healthcare agent. Here, these are their wishes. I'm bringing you their wishes. Please honor their wishes. They wouldn't want to live this way. Please end life support or don't start life support. In one instance, again, Elizabeth, to your point, what point can you step in? Even if the person still has capacity. I had a client who mentally was fine, but he had CPOD and the breathing machines were just declining working. And his oxygen levels are going really, really low. And the time was coming. And they asked, do you want to be hooked up to life support? He looked at his daughter and said, I can't make that decision for myself. Let her make it. Now that was tough, very tough. But she knew what he meant. She knew what needed to be done. He told her what to do. They had a communication, unsaid. He just couldn't leave her. And so she had to say, it's okay to go. So.
Wow. Joseph wanted to know, can you have co-agents for a healthcare proxy or a living will in New York State?
Yeah, so that's a very interesting question. The answer is no. You need a point guard. Imagine you have two kids or a spouse and a kid, and the spouse says, do the operation, and the kid says, don't do the operation. The doctor's like, wait a minute. Like, I'm just going to do what I want to do. Because if I listen to one of you, the other one's going to sue me. So they don't want to hear it. So you appoint one, then you appoint a second, you can even appoint a third. Reality is, I always encourage everybody, you guys should be working this out as a family, right? Because this person is important to everybody in your family. And when New York, we have the Family Decision Making Act, where you don't have a living will, you don't have a healthcare proxy. The family's got to get in a room in the hospital, duke it out, hammer it out, and decide as a family. And everybody's got to be 100% on board. So if you don't have these documents, you're hanging in the winds while your family's having a discussion. That's not it. That's not where we want to be.
Yeah.
So you pick the right person. I've had people pick people, and then they saw them in a medical situation, and they're like, "Oh no, 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 no! They fell apart. I don't want that person anymore." So
Not everyone is right for this role.
nope. But you do what you can right now, and whether it be these documents or the other ones we're going to talk about, I always say we have a cast of characters in our life, right? And we all know who they are, good, bad, and ugly. Everybody's got strengths and weaknesses, and everybody has a level of that you can trust and a level or not trust, a level of communication or not communication, and what makes sense. So you pick the people that you trust that will honor your wishes. So that's really how these two documents work. Powerful tool.
A couple of quick questions about that, if you don't mind. Terrence wants to know, so what's the difference between a healthcare proxy and a power of attorney?
Okay, in some states, it's called a medical power of attorney, not a healthcare proxy. New York specifically uses the word healthcare proxy and a healthcare agent, the person. So the power of attorney in New York and most states, unless it says medical, is for financial affairs. So there's medical decisions and financial affairs. Frankly, there's nothing else that needs to be covered. Either we're handling the financial side of your life or the physical side of your life. Those two things cover it all.
That's a good thing. Now, I had asked you this before, but Deborah wasn't sure. So with the healthcare proxy, if a person is fully cognizant, does that step in, or do you have to be specific about that in a healthcare proxy about the level of cognition?
We make it detailed enough, but not detailed enough so that it can kind of cover all the situations. I'll give you an example. You know, this man who said, look, she's got to take over. Like, that was a guy who knew what was going on. He just didn't want to, right? So, but other people, I had a situation where a son was helping his 92-year-old father who had prostate cancer. He was told he had 3 weeks to live. He also had full-blown Alzheimer's. So anyway, at some point, he had labored breathing, and they rushed him to the hospital, and the doctor says, incubate. And the nurse is standing behind the son going, don't do it, don't do it. And the son called me. He's like, what do I do? I'm like, well, okay, I'm not the doctor here, and doctors are supposed to preserve life at all costs, and we want them to in most instances. But in this case, is this going to prolong his life inevitably? Is this going to be more painful than not? What are we doing here? Is he going to have to live with that thing for the last 3 weeks of his life, or do we want him to be at peace? And he came up with the answers, ultimately did not put the ventilator in. And then he wound up passing away with calm breath within the 3-week time period. So I'm not going to say, if I'm terminal, don't put life support on, or do put life support on. You know, I can't say. There's so many. I had somebody on life support for a year that after a year, she actually lived when they took her off.
Wow.
And started talking again. Like, yeah, it's too many scenarios that you have to be specific and vague at the same time so you can cover what a person really wants and needs.
Well, like you said, you need the skeleton there.
And so, power of attorney, next document. This is, I think, the most important one in your arsenal of asset protection and elder care planning, right? So this is appointing somebody that you trust. And to Joe's question, could be more than one person at a time on this one. And this is to help people with their financial affairs. So if we hadn't done any planning and now we're in a crisis, except we did a power of attorney, then the person you legally appoint that you trust with your money can do trusts, can move assets, can get you the care paid for that you need. It's really important, and it's important, again, from age 18 to help somebody handle their money. So your daughter is 19 years old. She's got a bank account. If the bank account is at a local bank on Long Island and she's away at school and she can't get anything, is the bank going to let you just walk in there and take money? Of course not. Or that goes from 18, but picture the, the 92-year-old, this guy's in the hospital. He has bills to pay. What do we do? There's so much to do. And this saves everybody in the financial situations of the world. I would rather do it in advance and get the right people on there than do it when things are in a crisis mode. I had a client come in, a cute little couple, and the wife had it all together. She's 86 and the husband is 90. They had never done documents and he was with it, but very weak. And I had to get him to sign a 14-page document. Wow. To do a power of attorney, and he needed care. He was mentally fine, physically bad, and I needed to get him to sign these documents, and it was tough. And he couldn't stay in the lines, and you have to stay in the lines, and then the banks call it fraud, and it's a whole big to do. And you want these. Now, picture yourself. I don't know the age of anybody on the workshop today, but picture yourself. You're a person in your 40s. You have children. You're raising by then probably around teenager-ish. And something happens to you. You're in the hospital. Who's paying the bills? Who's taking care of you? Because now you can't take care of your entire family, right? Or, what if we have to tap into the 401k, to pay the bills? I can't go tap into somebody else's 401k, so it's tricky. And here's the thing, okay? As a caretaker or a spouse caretaker, the perception is you're automatically the person that can go in with authority and take care of financial affairs without a power of attorney, right? I'm a spouse. We've been together 40 years. What do you mean I can't go touch the life insurance or bank account? It's not going to happen. The banks and financial institutions are very, very clear. Well, what if I have to move the house? Nobody is going to let you sign your spouse's name. That's called fraud. You go to jail for that. So let's not do that. All right. A spouse cannot handle their own spouse's financial affairs, period, or make medical decisions, period, unless somebody lets them.
That's a huge point. That's a huge point. Your marriage certificate is not a document that allows this.
I had a case. This is riddled with fraud. I mean, I'm not against the institution of marriage. However, they're not all good ones. And we have situations. I had a situation this month that a woman was a longtime client and she had money. It was a second marriage. And she was not well. Now we normally hear from her and 2-3 times a year. We hadn't heard from her this year. And all of a sudden this husband said, hey, she wants to move money over into my name. So can you just have that done? And we said, what? All right. So we picked up the phone and we called her and she said, what are you talking about? And the husband was trying to take the money out of her name so that when she died, the daughter wouldn't get anything.
Wow.
It happens. It happens a lot, unfortunately. It happens a lot in bad situations, things of that nature. So,
and you never know what could turn into a bad situation too. People can be strange when people get sick or when money's involved. So you might not even realize there could be a bad situation. This kind of prevents a bad situation.
Correct. So that's why the financial institutions are so, protective. They have a fiduciary duty to be protective. When I'm in my financial planning world, I have a fiduciary to protect a person and make sure nobody else calls in on their accounts. So it is important. So that's where your power of attorney, again, is just the most vital document because it's so powerful. And here's the problem. People that have done their estate planning a while ago, the law changed on the power of attorney in 2010. Now, my document, that seems like a long time ago, but people put these lovely folders of estate planning documents away in a vault and they never look at it again. They go, yeah, it's done. I did it. If it's needed, it's there. You need to look at them every 5 years at a minimum, unless your cast of character changes. So if somebody moves, somebody dies, somebody's sick, or you don't like them anymore, you can change these documents, but you have to remember to do it. But in this case, in 2010, the power of attorney law changed, and the documents done before 2010 are out. So you try to present those to a financial institution, they won't accept them. It's very difficult. And so check your documents if you already did them, and make sure they're up to date under the power of attorney law change. And you have something called the statutory gift rider. I'm spending a lot of time here because this is another critical one. The new law changed my 7-page hand-tailored document to 15 pages.
Wow.
With exceptions and rules and parts. There's 2 separate parts of it. I have clients that come in and they're missing, they did it, but they're missing the whole second half of the document because they went to, believe it or not, somebody went to like a storefront convenience store and somebody was doing powers of attorney for people, $100.
Oh my gosh.
And it was frightening what came in my door. And I called them, I said, what happened? Why did you do this with this person? Well, I'm not an attorney. I don't know. So it's out there. There's a lot of bad ones out there, but the bottom line, with the power of attorney, the law changed. You need this second part, which says, yeah, you're the person that's I'm appointing to handle my financial affairs. But are you allowed to gift to yourself? So imagine in a spousal situation, one person's sick, we need to move the money to the spouse. You would now have to have the power to do that because of this statutory gift statement. Okay, it's the second part of the document that's new. And because there was fraud there too. Wait a minute, I'm the power of attorney. I can just move the money and do what I want. You really can't, but you could at that time. So now the gift writer says, are you allowed? Do I trust you enough that you won't run off with the money? And here's a case in point. Client, no, a prospective client, I wouldn't take her on as a client, came in with her mother's power of attorney. And it said she was a power of attorney and mom was failing mentally. And she noticed that mom's will left everything not to her only daughter, or her only child, but to charity. So the daughter says to me, well, I'm the power of attorney. Can I just do what I think is right? Because I know my mother, she wouldn't have just left it to charity. Her intent, I'm sure, was to give it to me. I said, well, that's not her intent. Her intent is to give it to this charity. And she said, yeah, but I'm allowed. I'm the power of attorney. I can just do it, move it. I'll protect it for her. I'll make sure it gets to the charity. And I swiftly discouraged her from doing that and said, thank you. And like, just prayed to God that she didn't go off and do it, but the old power of attorney letter. So now you have to say, here's my power of attorney, but they have a conflict of interest and they're not allowed to gift to themselves. Things to think about. The power of attorney law, hot topic right here. June 2021, we're having another power of attorney law change. And because we've been finding that the banking institutions don't want to accept the power of attorney. They go, oh, we don't work under New York law. We work under banking law. So we don't have to accept your power of attorney. And then we wind up having to fight with them as lawyers. So I am on the New York State Elder Law Bar Association board, and we go to New York and then the banking and all the different places in the state of New York and say, hey, these rules make sense, these don't. And we work with the legislature to try to like get things to make sense. So in this case now, banks will actually have sanctions if they don't accept a valid power of attorney. So this is really good news.
That is good news. Quick question. A bunch of people were just wanting clarification. You said for healthcare proxy, you should only appoint one person and then backups.
Correct.
And with the power of attorney, is it the same? Or can you?
You could do anything. You could have 1, 2, 3. I really don't recommend more than 2 at a time, but because it gets confusing. But you could do more than one person at a time on a power of attorney.
Got it. Thank you for the clarification.
You know, given the case of like this older couple I had, right? Mom's 86, she's a rock star. Like, who does she pick? Right? Who gets to be her power of attorney? Her kids. But now she wants to be power of attorney for her husband. Reality is she can't do it by herself. It's hard for her to get around. this particular person, so appointing her and her son together on his, that was a good move. Split the job, make it easier, that kind of a thing. So here's another one, perplexing people don't know. Power of attorney doesn't even work with Social Security. There's a special power of attorney when you go to Social Security called an SSA-11. It's in the middle of my screen here, if you can read it. And you literally have to fill out the Social Security form. Now, if the person's incapacitated, too late, you can't access their stuff. But that's why you get this stuff set up in order. If somebody gets a diagnosis of any physical or mental ailment, and these are the things that you should put on deck. Appoint your trusted person to be able to talk to Social Security. And all of the other financial institutions that you work with, but this one's a tough one. Now, there's another thing, a tool that you all should be doing for yourself. And this is, checking into your Social Security portal with the IRS, with Social Security, IRS, different subjects. So if you go to the Social Security website, again, ssa.gov, then there's a little thing on the bottom of the screen that says My Social Security. That's your portal. You go there, you can go in, tap in. They ask you a lot of security questions, things like, I can't believe they even know that anymore. Like, what street did I live on in 3rd grade? They know things. So, but then you can see everything. You can see if you retired or what your family benefits might be, all of it. It's really important to know.
It's very easy. It was very easy.
You did it?
Yep. And it was very easy to do.
Okay. So yes, so I highly encourage this one. But the bottom line is, if we don't do the power of attorney, or we need to help somebody with healthcare, you only have one other option, and that's a guardianship proceeding. And this is not a good option. This is an expensive option. This is a time-consuming option, and something that could be completely avoided. And not only that, it's degrading in many instances. So what happens is, if a person doesn't have a legally appointed person in their power of attorney to handle their financial affairs or physical affairs, then somebody has to petition the court to be guardian. And that means there's 5 attorneys involved. The judge gets an attorney. If you're the petitioner, you get an attorney. There's a court evaluator attorney, and then the list goes on of all the people involved in this thing. And if somebody else wants to do it, they can object to you doing it, and they get attorneys. Everybody gets criminal background checks, and so it's a big deal. And you're looking at 5 digits in fees for this type of stuff. So not necessary. So this is not a place you want to be. I had this little old woman, and this was a mess. She was 87 years old. She never did a power of attorney. Her husband handled everything for her. And she had a daughter that was 52 who had special needs. Mental retardation in an extreme way. So now she's losing ground herself. She has cancer, the beginning signs of not being able to mentally handle things. And she actually had a person take advantage of her. Her and her daughter would go every day to the pizza place. They lived in Queens in houses that were right next to each other, and everybody knew each other from the neighborhood for 40, 50 years. So the neighbors were watching, but they were on their own, and they had nobody else in the world. So what happened was, they would go to the pizza place every day, and the pizza delivery guy noticed this, and then he'd also deliver to them on bad days. So all of a sudden he's like, seems like you might need a little help around here. So he warmed up to them and brought them free food and started doing their errands and all kinds of things. And then wound up saying, hey, you know what? Let's go, since I do all these things for you anyway, let's go get a power of attorney. And they went to one of those storefront places and got a cheesy power of attorney. Yeah. And then started saying, oh, you know what? You have 2 floors and nobody's renting your upstairs apartment. How about I take it? And then I'm here for you all the time. So then he moves in. And then next thing you know, the neighbors are noticing Raymore and Flanagan trucks, 2 couches, 2 bedroom sets, 2 televisions, everything in double, triplicate for this house. And this woman never bought anything. So all of a sudden it's a whole situation. And the neighbors kind of rallied around it to say, hey, something's really wrong here. And she actually also did a will, got somebody to do a will to say, I leave everything to this guy because he promised to take care of my daughter if I die. I mean, total elder abuse fraud. So now this is a case where there was a power of attorney. We found out that he had stole like a few $100,000 from her, and really was going to leave this woman in God knows what he would have done with a 52-year-old. So we had to go to court, and I had to march this woman into court, sitting at the table like she's just sat there crying the whole time, and the judge is trying to talk to her, and she's like, I didn't do anything wrong. I don't want to go to jail. And she didn't even understand like why she was there. It was traumatic, horrifying, horrible. And we had to prove the fraud. But bottom line is we had to get the right person in charge of her. And so not a place anybody wants to be. You can't imagine this happening to you. But if you don't appoint somebody, this is your only route. Do the power of attorney. This stuff is simple enough to do with like 2 appointments. All right. Any more questions on these documents before I move forward with the when you die kind of stuff?
I think we're good. We're asking questions all throughout. It's been good.
Excellent. All right. So we talk about the last will and testament. Again, different than a living will. Living will is your will of if you want to live or die. But your last will and testament is your last statement for when you die, who gets what and how they get it. Now, people are familiar with them, seen them in the movies, maybe experienced them yourself, but also you could do this by what we call a revocable living trust. So I will explain what goes into both documents. The first thing is the executor. Now, you make a will and it says who gets what and how to get it. But you need to put a person in charge of that to petition the court to allow that person to have the authority, who the court will watch, to make sure that that person does their job. So if you're the appointed executor, your job is to collect all the assets and then spit them out to the beneficiaries the way the will reads. Now, it could read a lot of different things. It could say, and their job's done after that. They, do an inventory to the court, and their job is done. It's over. Now, there's more things to it, though. The will also has, could have some trust in it. You could say, I leave everything to my spouse and then my children. But if one of my kids predeceases me and I have grandkids, then I could do a trust for my grandkids. And that trust, you put a trustee in charge of. And we also pick an age when the kids get the money. So for example, we say, if there's any beneficiary that's under the age of 25, then it goes into a trust for them. And, my son, George, is going to be the trustee. And George is going to be the trustee and going to spend the money on this child as if I would spend it on this child. So if you have kids under the age of 25, you'd put somebody in charge. If you're a grandparent, you still want to think down that family tree because anything could happen. You both could be you and your kid could be in the same car together, and then that's a tragedy. And then you have grandkids that are getting your money. So we cover all the scenarios with this trust, but it's called a contingency trust for minors. That says, again, this money is for this child, but if they're under 25, somebody's in charge of spending it. And when they're 25, they get the leftover of whatever's in the checkbook. So it could be spent on college, a wedding, a computer, travel, whatever. But they don't get this money at 17 years old when they just got their driver's license and say, hey, I got $100,000. I'm going to buy a Tesla. Trust me, many teenagers want a Tesla today. So
very true.
So that's the situation. But we also do trusts for people with special needs. So children and grandchildren with special needs, or nieces and nephews that say, this money, I really want this person to receive money, but I know there might be get government benefits involved. And so this money is in a trust with a trustee I appoint to supplement, but not take away government benefits. Okay, so this is another key takeaway that you want to have. Appointing the right people to handle the jobs and getting the money to the right way responsibly. I did have a client who had $10 million and he only wanted to leave it all to his one niece who was just turning 21. And I really discouraged him from just giving it to her. A 21-year-old that gets $10 million has no idea what to do with that. And you want to talk about burning and crashing a life that could just completely spin out of control. So she's lucky enough to get the money, but how about helping her live her life better instead of what could be a disaster? Too much of a good thing is not a good thing all the time. So that's a will. Problem with a will is that it takes a while. There is a cost to it in the court, and more than just setting everything up with beneficiaries and not using a will. And not only that, if you have property in other states, if I have to probate or take care of your will in New York and you've got a condo in Florida, and I've got to go then do a whole nother probate in the court of Florida. And so there's reasons why we don't want to just do a will. Not only that, creditors. If you have creditors, or say we're going for long-term care Medicaid, we got a problem because they're going to be the first. If you get on Medicaid for long-term care, guess what? They're going to be the people that are the first in line to get paid back, not your family. So wills are not necessarily the best. Trusts are better. And there's 4 kinds of trusts, but the biggest reason to use a revocable trust, revocable living trust, you see the ads in the newspaper for the workshops on them all the time. And it's good, but not necessarily the best thing since sliced bread, as some would attest to. We use them for the property out of state, like I said, pull it all into one place in a trust. And then I don't have to do a probate in either place. I don't have to go deal with the courts, less expensive. If I have squabbling heirs, I want to leave 90% to one kid, 10% to the other for whatever my reasons. They can walk right into court on a will and boom, have a lawyer and boom, start a litigation. But if you have these revocable trusts, it's very hard to do that because we never made it to court. So they got to go by themselves. And then it's a quick transition. So you take your assets, you create this trust document that says who gets what and how I get it. And then I put the assets in it. And the day I pass away, they automatically become these people's. So it's a nice transition when things go tragic. It does avoid probate and it is in your social, so it doesn't change anything for your life. But now let's get to the most important part. I know time is short, and I want to talk about the irrevocable living trust for asset protection for long-term care and Medicaid. Now, some people say, yeah, I don't need to do that. I'm just going to spend all my money. And some people say, I just want to buy long-term care insurance. And other people say, no, let me protect it. And so I say we do a combination of all. This is the Medicaid Asset Protection Trust, the MAPT, right? It is an irrevocable trust. You use this, you put your money in or your house in, and it protects it. Consider it like a complete protective barrier. I always talk about it like it's kryptonite that Superman can't get in there. So those assets are protected in that vault, but there are some catches to it. You can't just put it in and then apply for Medicaid to cover home care or nursing home care, right? So whatever assets we put in here, there's a 5-year look back period for nursing home care. So you better not be sick when this starts, because that's going to be a problem. And now we have some new rules coming into place for home care. And this is the scary one. This is like hot off the press stuff again. This is huge. Anybody that you know right now that may need care in the next 2.5 years needs to run, not walk, and get their planning documents done and start getting assets protected, because the current rule, the old rule as of before January 2020 was that we can transfer our assets and apply for home care, right? For custodial care, which costs like 7 to 10,000 a month, and have no penalty periods. I could transfer today, do a Medicaid application tomorrow. So people thought they have time because they're not going to nursing homes ever, as they say. And when that time comes, I'll do it. So they don't get around to planning. Well, here's the news. They just after October 1 of 2020 said any assets transferred after October 2020, which is over, are subject to a new 2.5-year look back and penalty period for home care. This is super bad. And to make matters worse, now we keep hammering away at New York State to make a change because that wasn't fair to do during COVID, not notify anybody. Boom, all of a sudden this new rule is here. Nobody could do anything about it. And so right now, by July 1, maybe by January 1, if you put your assets into these trusts or do any kind of gifting, and if you make a Medicaid application for somebody that truly needs care right now, by July 1st, hopefully extended to January 1, then no penalty. But if you wait till this rule solidifies, then you have a 2.5-year look back and penalty. So do you have $7,000 to $10,000 a month to risk just in case you fall in this 2.5-year time period? I think many don't. And so if you have anybody that has first signs of dementia, needs any kind of care, you could see it happening in the next 2.5 years. Run, don't walk, get this done. You've got to get assets into the trusts and do other protection planning things depending on your personal situation. And then you have to apply for Medicaid. So that's what we're doing for people these days. We're doing the protection planning. Again, do we want to do this in a crisis situation? No, but we can with a power of attorney. But we don't really want to. We want to plan properly, methodically, when you're calling the shots and making the choices. So the asset protection trust that we're using is irrevocable, but of course I have some safety nets to get us out of here if something happens in a 2.5-year or 5-year time period. We have to pick a separate trustee, so you pick people you trust to be in charge of it. The people that set it up, you can get income from this trust for your lifetime, but the principal is protected and the house is protected, right? The good news is you as the grantor have some control. You can always change your trustees if they're doing things that you don't want them to do or won't do things that you do want them to do. And you can change your beneficiaries. So your trustee is acting like a not nice person. You can cut them out in multiple ways. Or, you decide, hey, I want 25% to go right to my grandkids. Forget the kids. You can change the beneficiaries. So you have a lot of control, but not if you don't set it up. Now, here's the other issue. Okay. What do you do with the house? The house, we do not want this to be happening. Right. First thing people say all the time is, I'll just give it to the kids. I've got the best kid in the world, totally trustworthy, right? Well, here's the problem. Your kids could have creditors too. They could get in a car accident, somebody could sue them, and then your house is not protected, right? But the worst issue, and this is something really, really, really important, is the tax issue. So if you transfer your house to your kids, you lose your senior star, veterans exemptions, and all that stuff. But if you put it in the trust, you get to keep all those exemptions. And you get what we call the step up in cost basis at death. So that means when you die, if it goes into the trust, your kids inherit your house at fair market value. If you paid $22,000 for the house and it's $500,000 when you die, they get a house in the trust with $500,000 automatically with no capital gains. If you give your kids that house, they get a $22,000 house. When it's sold, they're paying big bucks in capital gains. So these are things you don't want to do. And the bottom line is, we can talk about IRAs again another day. I want to get to your questions. New rules about IRAs and distributions. You cannot not look at this. We have to look at how IRAs get distributed for long-term care and for your heirs. mostly they're protected for long-term care if they're handled in a certain way. So you got to have your dream team, the lawyer, the accountant, and the advisor to pull this all together for you. Thank you very much. I am happy to answer questions for you. I know we went through something pretty quickly, but I'm open to questions. And you can always reach me by email or by phone to go through a consultation, a free consultation, or to see what your needs are. Thank you.
Wow, Donna, thank you. That is such great information. We do have some questions. We did address some of them during the presentation, which is great, but we definitely have a few more that I'd like to address with you. But
Bring it on.
What?
Bring it on.
Wonderful. I also want to let everyone know that I did put Donna's website and her phone number in the chat so everyone can see that. You'll also get an email tomorrow with that information. Also, everyone was asking, this is being recorded and we will be sending a link out. It will also be available on the Schneps Media YouTube channel, but we're also going to send you a link tomorrow along with the contact information. So you'll be able to watch it again and again and share it. So that's good news. So let me get to some of the questions here that we did not address yet. Robin asks, I'm 65 and will be buying a new co-op apartment. Should I put it in a trust from the date of purchase?
So it's worth two things: the consultation in advance so that you figure out your personal situation as to why you'd want to put it in a trust. Co-ops are tricky. Sometimes the co-op boards allow us to put things in a trust and sometimes they don't. But if you're getting a mortgage, then you have to do that first. And I wouldn't involve that at a closing. And so you want to run all those numbers first and then do it after the fact. Yes, there's additional charges because you have to do another transfer of the shares into the trust. But it may be worth it just to keep this clean. Buy it, then we do it separate. Unless your situation avails itself, which we'd have to look at individually, but I'd be happy to help you with that.
Great. That's a good overview answer, and certainly digging in deeper one-on-one would be great. Marlene wanted to know, may a person allocate personal property by videotape?
People do very creative things with that. I've had people do Polaroids all around their house, things of that nature. And I've had people write things on the back of things. You could do whatever you think your family will honor on that.
Great. Jerry wanted to know, and I'm not sure if this is in your wheelhouse, but if a disabled adult child is receiving Social Security under the parent's SSI, under the parent's Social Security, and the parent passes away, does the child continue to receive SSI, or is this something that would need to be set up prior to death?
So SSI is not regular Social Security income for the rest of the audience. It is special income for disabled adults. It gives them income to be able to function in society, get an apartment or anything, if they're capable, but it's income to help them. It's not like your regular Social Security. So once they obtain that benefit, it doesn't die with their parent, especially when they're already an adult. Usually you can't even get it unless you're emancipated. So that's a different benefit that you could keep.
So it's not something.
However, you better do your planning as a parent because you can only have $2,000 in your name at all to get SSI. So you don't want to get, leave the kids something outright. We need to use those special needs trusts. And then that supplements the SSI that they get. Very careful.
Very important distinction. Thank you. George wanted to know, and actually we also had someone else who asked a similar question. If I move out of New York State, is my already existing revocable living trust still good, or do I need to get a revocable living trust in the new state? Also, someone else wanted to know in regard to any of this paperwork, once you move out of New York, do you have to redo it all?
Happens all the time, right? Yes, we're all on the move. And so in my irrevocable trusts, I make them pliable so that if you go to different jurisdictions, you can go by the laws of the jurisdiction. So it's important when you move on the irrevocable trust to check in with an elder law attorney to make sure everything is still good there, because every state has some slightly different rules, and you can adjust them. So you don't have to get rid of the trust that you have necessarily. Same thing with the revocable trust and the other documents. If they were valid in the state that you lived in, that you were domiciled in at the time, they have to honor them. Would I update some of the more simple ones? The power of attorney, healthcare proxy, living will, those living documents? Yeah, I would. But a state has to honor an out-of-state will and the irrevocable trust, but we have to make sure that they all jive.
Okay, terrific. So it's something.
And I'm part of an organization called NAELA, which is the National Academy of Elder Law Attorneys. So it's NAELA.org. And you can go to that website and say, I need to understand what the rules are in Washington State. And you look it up and you find all these elder law attorneys that do exactly what I do in those other states. And is a huge tool, huge tool.
Can you share that website again? I'll put it in the chat.
NAELA.org.
Perfect. I'll just put that in the chat so that everyone will have it. Linda wants to know, thank you for that, is the 2.5 look back for home care in addition to the 5 year?
It's in the same time period, yes. So it's 5 years for nursing home care, 2.5 year for home care. So that means what we'll be doing is collecting 2.5 years of data down the line here in order to make that home care application. But if you then go to the nursing home, I have to collect 5 years of paperwork and data. They're looking for transfers. They're looking to how you got down to having no money to qualify for Medicaid. And they'll penalize you for it if it's not legit. And if it was done, if you transferred assets, if you gifted to trusts or outright or whatever, unless you just spent the money on yourself, there's a penalty involved. And then you won't get the care paid for. And you better find a way to cover it. And if you don't, and say you're in a nursing home or getting this home care, these nursing homes are not stupid. And now they all have lawyer teams that they've outsourced, hired to go after the people that were gifted to get the money back. Wow. So they'll go after your kid who got gifted that house if you don't find a way to pay for your care.
Yeah, so it's really very important that you talk, because it's so confusing. It's really very important that you talk to a professional and get that advice. Yes. Thank you. So Cynthia had a couple of questions that she sent in actually ahead of time. And she said, I named a charitable nonprofit beneficiary for my several cash and IRA accounts at Fidelity. I now understand that I can only designate a beneficiary for my IRAs. What about my cash accounts, which are actually the bulk of my financial assets?
I mean, you absolutely can. There's no reason why you shouldn't be able to put on a beneficiary form, whichever one of the charities you picked. So, but if Fidelity is saying no, you can, call somebody like me and I can help you get that done. You can also do it through your revocable trust. You could also do it through a will. So there's 3 avenues you can choose to do that. And yes, the IRAs you can definitely do, as you're familiar with. You can leave your IRA to charity, which is actually the best asset to leave to charity if you're going to be charitably inclined, because they don't pay income tax on the IRA like your heirs will. Oh. So I like using that for charity more than I like the other. Unless that's your choice and you only want to do charities, that's amazing. That's very philanthropic. And so then you do both, but right, we have to set them up differently.
Okay, terrific. She also said that she has no will because she has no assets, although it sounds like she may have some assets, but she has some nice furniture and things in her apartment that she wants to give to 2 doormen. And is it possible to handle that without a will?
So you got to have something in writing, right? Something in writing. And I would do a will, at least if you have the will. Even if we don't have to take it to court because there's no money, the doormen can come forward. They should know it if they're getting it, okay, so you guys are supposed to get this, but the landlord doesn't have to honor it if there's nothing in writing. So, right. You should have it in writing. Otherwise, it's probably, I'd hate to see something of value like that go in the garbage just because you had good intentions, but you didn't put it in writing.
Very good point. We have a lot of questions about Medicaid. Susan wants to know, what about income regarding Medicaid planning? And And, also Deborah wanted to know, is level of illness considered prior to the 2.5-year look back period?
Okay. So there's asset protection planning and there's income protection planning, right? The asset protection planning is where we do the trusts and the irrevocable trusts and stuff. The income planning, we do have a way of protecting income through the use of what we called a pooled, we jump in the pool, pooled income trust. They are run by charities. When we do a Medicaid application, Medicaid gives us a budget and they say you're allowed to keep $897 a month and cover your medical costs. So meaning, I'm sorry, your medical insurance costs. So maybe it's like $1,200 a month, but you make, $2,000 a month. So what do? We don't want to just, lose that money. We have a mechanism where we set up one of these special kinds of trusts for income, and we're able to utilize that to protect all the income. So income is a part of it, but then you have your income in this trust to pay all your bills. So like the gardener and the electric bill and the extra aids that you want to get that Medicaid's not covering, or clothes or anything, you can spend that money every month, or the real estate taxes, things like that. Medicaid ain't covering it. So unfortunately.
Right.
And the second question was about, sorry.
It was about when you apply for Medicaid home care.
Yeah.
Is there a level of illness that's considered prior to the 2.5 look back period?
No. No, it's in the first place, irrelevant. You needed care, and so you have to do this. I mean, there's a hardship waiver that you could do. It's very, very hard to get, but reality is we make the financial Medicaid application first, then Medicaid comes in and does a nursing assessment on you at home, or in a nursing home, it's called a PRI. And then that's decided how many hours of home care you get. And in a nursing home setting, how much Medicaid will pay to the nursing home. But for home care, you need the care. There are requirements to be able to qualify for the care. You can qualify for Medicaid and then not have enough requirements to qualify for care. And you have to not be able to do 2 activities of daily living. And then dementia is considered one of those things right now. So, that's a big problem. Somebody can do things for themselves, but somebody has to say, hey, let's go take a shower. Hey, let's now eat breakfast. Hey, let's brush our teeth. They need somebody on a constant. They could do it. They could do the mechanics, but they need help. That counts. So there's 2 parts of this assessment. And some people get on Medicaid and then decide they don't want to do the actual nursing assessment, but then their benefits are in place for the future, which is not a bad idea in many instances. But I wouldn't do it if you're just completely healthy.
Right. Plan. So here's a question I think is a good one to end on that Lorna has. And
Okay.
she wants to know, is there a minimum asset level that should be reached before using services like yours? And I think, the question about, who should reach out to you, who's the right person to see you?
Okay. So this is really important. Unless you are a multi-millionaire, you qualify to do asset protection planning. This is a big, just like, money out the door if you don't do any protection planning. So I don't believe that you should spend on every single asset you have and then apply for Medicaid, because you still have needs in life. So you never want to get down to bottom. You're only allowed to have $15,000 in your name and your IRAs, and a prepaid funeral trust to qualify. But I would rather protect my assets, get through the time periods so that I can be empowered to have my money on the side and get Medicaid benefits to cover what they're supposed to cover. Look, these rules are in place for a reason. If you're willing to protect your assets and wait out the time, they're willing to pay for care. In other states, it's not so generous. And so it's really important to just check in on your plan. This is me. This is what it looks like. What do we do? What should I plan now? What should I put aside? When people come to me, I don't put all their assets necessarily in a trust. I say, hey, you have a long life ahead of you. Keep this money aside. What money are you willing to spend down on care if it came up quick, and money that you wanted to spend, go on vacations? have family journeys, buy a car, do whatever you want. Like you have a life. You don't have to put it all in a trust. And the trust we can still get to, but there's again mechanisms, and we offset by IRAs. So there's so much to consider. Like just when we come down and we do this 20,000 foot snapshot look, I can say, now is the time to do this or that. And when a care need arises, you better have already done some of this planning, because then we're starting to run out of time. So plan ahead, and then I can tell you, or other elder law attorneys as well. I mean, we can tell you, these are your risks, and then you can assess the risk of how much to spend, how much to save and protect.
Well, everyone should take advantage of Donna Stefans' very generous offer of a free consultation. So please reach out to her to do that, because as we can see, planning is really what's critical. Whatever your situation is, everyone's different and everyone has different needs, but no matter what it is, planning is really critical to take that weight off of your shoulders, and also take it off your family's shoulders when they're mourning your loss. So it's really a piece for you and your family. So I want to thank you, Donna. This has been pure gold. So thank you so much for your generosity. And I want to thank all of our attendees for joining this morning into afternoon with us. I so appreciate your being here. I'm seeing so many thank yous. Some people are so appreciative of this information. Again, we'll send you Donna's contact information and a link so you can see it again and share it. So please do. And I want to wish you all to stay safe, stay healthy, and look forward to seeing you on a future webinar. Thanks so much.
Thanks, everyone. Happy to help.
Thank you, Donna. Bye-bye.